I would do a little bit of an intro as to what exactly the task force is doing and has been doing in the last little while to prepare for the post-election fight against Bill 96, which our guest, Michael Bergman, is very much involved in. So I thought I would do a little bit of a scan. We are dealing right now with the fact that Bill 96 is now law. François Legault is premier with a huge majority, and the Coalition Avenir du Québec dominates Quebec and Canadian politics. Legault is now effectively the most powerful premier in the country, and he's little opposition to his project to create a nation in Quebec. The Trudeau minority government fears him, and his provincial colleagues are in awe of his success, despite his connections to nationalism and xenophobia. It's a dispiriting moment for Quebecers who believe in an open, tolerant, and bilingual society. But all is not lost. While Bill 96 is now Law 96, the courts have yet to be heard from. As this egregious law is unconstitutional from beginning to end, it remains only to prove that in law. To that end, we are joining forces to fight Bill 96 on several fronts. The Task Force on Linguistic Policy is bringing to bear its status as a nonprofit organization with hundreds of members and thousands of supporters. The Bergman law firm is bringing its knowledge and experience. We plan a full frontal assault on Bill 96, which will fight the law in the courts of justice and public opinion. In order to do this, we'll need support and money. Both are crucial. In terms of public support, we need to show our cause is important, progressive, and representative of a huge cross-section of Quebec society. Funding will be necessary because taking any case to court is expensive, and more than likely, these cases will end up in the Supreme Court of Canada. We plan to fight this battle on several fronts with plaintiffs from across Quebec society who will take on the law's implications for them. Most tacticians wouldn't reveal their strategy in advance, but we have no choice as we need people to come forward in this effort. So here's a summary of the cases we'll pursue and the plaintiffs that we will seek with Michael Bergman. An individual who will be a plaintiff acting as a public interest litigant as a constitutional question. A Canadian citizen who did not go to elementary, primary, or secondary high school in English in Canada. In other words, someone who is not an historic Anglophone as defined by Bill 96. A business person or corporation whose business and commercial affairs will be affected by Bill 96 and notably failed the requirement for francisation. A permanent resident in Quebec who will no longer be eligible to receive communications in English from the Quebec government after 6 months of landing here. A notary who's now required to register Ontario documents in French or English, accompanied by a certified French translation at the expense of the client. A business whose internal documents and software only use English and who would be liable to arbitrary search and seizure by the Office québécois de la langue française. And finally, an English CEGEP student who would be required to take at least 3 courses in French in 2023, 2024, and whose grades could be adversely affected by that situation. If anyone sees themselves in these descriptions, we're calling out to them because we need people of good faith to support those people. They'll be our A-team of courageous individuals fighting the enormous power of the CAQ government and this egregious law on behalf of all of us. The stakes are high. As it currently stands, Bill 96 has the potential to deny millions of Quebecers their right to live, study, and conduct a business in a free and open society. Fortunately, we live in a country where the rule of law is supreme and where political expedience, nationalism, and prejudice have no presence in the courts, where the right of a minority is to be protected from the tyranny of the majority, and that principle is sacrosanct, where justice is the counterweight to demagoguery. Our cause is just, and our time is now. Now, let me introduce Michael Bergman. Michael Bergman is a veteran legal strategist, a tenacious negotiator, and a seasoned litigator. He is the founder and principal of Bergman and Associates Lawyers. Going on 40 years of law practice, he's pleaded before the trial and appellate courts of Quebec, Ontario, the trial and appellate court, federal courts, the Supreme Court of Canada, the United States District Court, and diverse administrative bodies. Mr. Bergman has represented clients before official committees of the Parliament of Canada and the National Assembly of Quebec. He has steered and coordinated international litigation between several countries. Mr. Bergman graduated from Montreal's McGill University Faculty of Law, where he completed both the Civil Law program, Bachelor of Civil Law, in 1975, and the Common Law program in 1976 with the Bachelor of Laws. He's trained in both English Common Law and French Civil Law. He's a member of the Barreau du Québec, the Law Society of Upper Canada, the Canadian Bar Association, the American Bar Association, the International Bar Association, the Association of Trial Lawyers of America, and the Lord Reading Law Society. He's written many articles and opinion editorials in English and in French, which have appeared in the Montreal Gazette, La Presse, Le Devoir, the Montreal Business Magazine, L'Économique, and various trade magazines. Michael Bergman is called upon as a commentator, panelist, forum leader, and guest speaker at many conferences, and we are really privileged to have him here with us tonight. So without further ado, I would like to ask Michael to take the floor.
Thank you very much for that warm welcome and that lovely introduction. I may add that I also lecture in language rights at the Faculty of Law of McGill University. I'm going to take a few moments to describe Bill 96. I know that all of you are convinced that you've heard enough about Bill 96 to understand its scope and its implications. I can also assure you with respect that you're all mistaken. Very few people understand the battlefield of Bill 96. Bill 96 amends the Charter of the French language. It's a bit of a misnomer to call it Bill 96. It's really the new, upgraded, upscaled Charter of the French language. This Charter of the French language, though, has limited relationship to the original Bill 101. This charter is revolutionary and radical. It reframes, reorganizes human rights and freedoms. It does this to render French the common language of Quebec. The common language meaning the language of public discourse, of work, of leisure, and just about anything in the public space. To render French the common language, it declares the right to the French language, the right to the French language, the pinnacle priority right, which subordinates all other human rights. In other words, the right to the French language takes precedent over every other freedom and liberty, period. With that right comes the obligations of all Quebecers to facilitate and support that right. You are, in the coming year, will be obligated, at least indirectly, maybe directly, to support the primacy of the right to the French language. Secondly, Bill 96 creates a new category of rights, a category that is largely unknown in the Anglo and English Canadian American legal tradition. And that is the collective right of Francophone Quebec to its language, culture, and identity, subordinating all individual freedoms. So let's understand the collective right of the majority population of Quebec takes precedence in all events over every individual freedom. The English-speaking minority of Quebec have no collective rights, meaning in any court fight, debate, argument, which opposes the collective right of majority, our ability to argue our individual freedoms will not count, period. This is an amazing change in the structure of rights and freedoms. Collective rights are understood in parts of Europe and other parts of the world, but certainly not North America. Collective rights traditionally was the right of the state to repel foreign invaders and foreign competitors. It was not used as a domestic right. In support of this reformation of rights, the Charter of the French language now uses the notwithstanding clause, meaning that for 5-year terms, the constitutional charter, for the most part, has no application. So in the scheme of things, if you want to argue your freedom of speech, that will not work unless the courts find a way to restrict or get around the notwithstanding clause. Bill 96 also amends the Quebec Provincial Charter of Rights and Freedoms to exclude its application from the Charter of the French language. For this, there is no limit. This will continue indefinitely forever unless the National Assembly amends it. The significance of this is the Quebec Charter applies not only to the citizen vis-a-vis the state, but it applies as to the rights between citizens. So for example, if you go into an establishment and you believe you're being discriminated against because you're using English, and the shopkeeper or whatever will not use English, and you file a complaint, that complaint will go nowhere because the Quebec Charter will not apply. The Constitutional Charter only applies to the relations between the individual and the state. The Charter of the French language engages other tools. The idea that every single law of Quebec, doesn't matter what it's about, you can have a law about beekeeping, must be interpreted to support the primacy, protection, and promotion of the French language. So inherent in every law will be this requirement. The Quebec Civil Code, which is a foundational law of Quebec, will also be subject to the Charter of the French language and similarly interpreted. You are well aware of some of the other features, the language requirements in English CEGEPs, the quota system for English CEGEPs. What you may not be as much aware of is June 1st, 2023. That's a calendar date you should note. On that date, no business in Quebec will be able to communicate with the Quebec government or its agencies in English. If you attempt to do that, whether orally, by phone or whatever, or in writing or in person, the bureaucrat or the agent, whoever, will tell you in French, not in English, that they can no longer deal with you in English, and you must please speak in French. On that date, if you are an individual calling about whatever, your income tax, your old age pension, your health care, calling the government agent will say to you in English, how do you do? And you'll say, I need to speak to you about whatever it is in English. And the agent will respond to you, thank you. But first, you must prove to me that you are an historic Anglophone. And the way you'll do that is by proving that you went to elementary or high school in English somewhere in Canada. If you can't prove that, then the agent will tell you that he or she can no longer speak to you in English. And if you continue the conversation in English, that person will say, I'm sorry, you cannot speak English. And if you propose a compromise, saying, I will speak to you in English, you speak to me in French, the agent will say that's impossible. If you did not go to elementary or high school in English in Canada, then under no case will the government agent speak to you in English or write to you in English. How you go about proving what school you went to 30, 40, 50 years ago is unknown right now. My guess is they'll create a data bank in which you need to register and show your proofs that you were educated in English somewhere in Canada at the elementary and secondary level. You go to your notary to sell your home. You want the deed done in English. Notary says, no problem, but I cannot register it in English. I will need to generate an official certified French translation that will cost you more money. So your choice is either spend more money to have the English version plus the registrable French version, or you just live with the French version. You can't sell property unless it's registered. So you really have no choice. You go before a judge of the Quebec court. You have to recognize that Quebec courts have two levels. Superior Court, where the judges are federally appointed, and the Quebec Court, or the Court of Quebec. The Quebec Court deals with lawsuits under $85,000 and with most criminal cases. You go before the judge, you speak in English, and the judge says, Je m'excuse, mais j'ai pas la capacité de vous parler en anglais. Because in the future, judges will be appointed to this court based on the sole criteria that they speak French. English will not be required unless it's determined that that is absolutely necessary and there's no other reasonable alternative. This is a thumbnail sketch of what's involved. But I believe that just from the few minutes that I've given you an example, and I have spoken on this issue in many forums to lay people and to lawyers, sometimes for 90 minutes. But you also understand when what you read in the media about Bill 96 is not the complete picture. There is a much more serious element that will reframe our understanding of human rights and liberties. There is nowhere to go any longer to lobby for change. It is clear that the National Assembly and parties of all stripes, not just the CAC, are not going to repeal Bill 96. Any political leader in Quebec who says that is BSing, to be blunt. There may be those who would tinker with it a little bit, making it a little more lenient or even a little harsher. So Bill 96, the modernized, radicalized Charter of the French language is here to stay. The only last place to go for redress are the courts of law to challenge the constitutionality of Bill 96 and the amendments made to the Charter of the French language. Right now, there are 3 or 4 existing court cases on this. But unfortunately, the cases do not cover what I have just told you. The cases cover the use of language in the court system, such as whether or not a corporation must, in its pleadings, written pleadings, submit a French version of any English pleading they wish to use, such as the appointment of judges, such as the interpretation of laws, whether the English or French versions of the laws, because the laws are bilingual, are equivalent and take equal precedence, balance the one against the other. So these cases really don't deal with what most Anglophone Quebecers in their day-to-day life will be dealing with or touched by or affected through Bill 96. One last thing. Bill 96 unilaterally amends the Canadian Constitution. When I say that, I don't mean a Constitution of Quebec, because actually Quebec doesn't have a written constitution. In fact, the only province with a written constitution is British Columbia. Bill 96 says that the Constitution Act 1867, which is the original Constitution at Confederation, is amended to add 2 provisions applicable to Quebec. And I'll quote them. One says, Quebec is a nation. The other says, French is the official language of the Quebec nation. French is also the common language of Quebecers. Now, whether or not these unilateral amendments are constitutional is highly, highly doubtful and dubious. But for the moment, today, these amendments are in effect. And how that will impact on the understanding and interpretation of the Constitution remains to be seen. Many issues arise also. For example, as you may know, the word nation in English does not have the same meaning as the word nation in French. Nation is more of an ethnocentric cultural description. Nation can imply everyone in Canada. So whether or not we are Quebecers, members of the nation, can be debated. If French is the constitutionally authorized common language, that may infect other parts of the Constitution, including language rights in the courts, language of minority, official language minority education in Quebec, and whatnot. It's amazing, though, that very, very few political and media commentators have raised this issue. But it is serious enough so that, if you may recall, and maybe most people have forgotten, that in June of 2021, the House of Commons adopted a near unanimous resolution proposed by the leader of the Bloc Québécois, with only 2 no's, saying that the House of Commons recognized the authority of Quebec to amend the Constitution unilaterally. This is quite remarkable. while most jurists in English Canada say such an amendment is impossible, there are many jurists in French Quebec who say that it is arguably doable. And in fact, we spent 40, 50 years debating the Constitution, Meech Lake, Charlottetown, I'm sure you all remember these, for nothing. Because Quebec just unilaterally did what it did. And if it's found to be constitutional, that is in effect creating a kind of or pseudo distinct society, which was debated forever and ever. So that's an overview. The question now is anyone ready to challenge Bill 96 holistically as a complete document, as a complete piece of law, whose provisions are intersecting and interlocking in court? Nobody has done that yet. I know of nobody who plans to do that or advocates that, except, frankly, myself. And I was involved in some of the discussions with at least one other lawsuit that focused only on language in the courts, and I did not agree with that orientation. If we don't meet this head on, if we do this in dribs and drabs over many years, it'll be too late, frankly. So now it's up to you whether you want to engage in this saga, this odyssey, which will go certainly to the Supreme Court, take a number of years, take a lot of time, resources, effort, cost money, and that's something to be discussed and looked at. Or you just want to accept what it is and do your best to lobby on the fringes, so to speak. One other thing quickly that bears saying, over the next 12 months, you will see a great many regulations from the government dealing with the use of the French language. This is because about 50% of Bill 96 is regulatory, that the new minister of the French language will oversee over all government agencies the exemplary use of French. And what they mean by that, they're not talking about grammar and syntax and using the right words and getting rid of slang. They mean that the French language is ubiquitous and used as much as humanly possible in all sectors of society affected by the government and its agencies and parapublic bodies. And that you may find when we know of these regulations to be very intrusive and disturbing. I know the government says that health, social services are really untouched. That is not certain. That is far from clear. There are issues there that need to be explored. I know that the government says English institutions will be untouched. That is far from certain. I don't claim to be a good prognosticator of future political events, so you can take what I'm about to say with a grain of salt. But I have a view that over generational time, and generation nowadays is about 5, 10 years, when all of us were a lot younger, it was like 20 years, that with the growing complete bilingualism of the community and the community's fluency, that one government somewhere in the future will say, all you ladies and gentlemen, you speak perfect French. Why do you need English institutions? Why should we spend more money duplicating institutions? And it may be one day in 20, 30, 40, 50 years, that the government financing of English institutions will begin to fade away. Now, whether or not demographic statistics, future politics, and prove me right or wrong remains to be seen. But if this Bill 96 is not litigated now, then down the road will be way too late. What do you want to do?